before we come before you at this time, we are always grateful for the fact that we are children of yours. Help us to hold close to your word and understand. Your sight. We ask this in your Son's name, Jesus Christ. Amen.
All right, and the first thing we're going to do, so I can bow out of this as elected chairman, but first let me say this one thing. The ethics committee, and I served on one before, it never had to meet, but this is it's an awesome responsibility that you have here to make judgments about things, and I respect each one of you for serving in this capacity. And looking at who we have on this committee, I couldn't be more pleased with the fact that I believe that a fair and just disposition will be made of anything that comes before you. From this point on, I will not be sitting at the table. I really think this committee should not even smack of anything political, just a just decision. When I come in to observe any more of the meetings, I'll be sitting out there watching you, and it should be the ethics committee. But I appreciate each one of you for taking this responsibility on. I'll have the floor open now for nominations.
We need to approve the agenda.
Oh, I'm sorry, yes. Do I have a motion to approve the agenda?
So moved.
I'm going to amend the agenda to strike item B off of the under new business. Make a motion to strike B.
Okay.
Second.
All in favor?
Aye.
Those like sign. B will be stricken. With that, do we have a motion to approve the agenda?
Second.
Motion and a second, without discussion. All in favor?
Aye.
Opposed, like sign. And now we will have, we'll be open for chairman.
I make a motion, Mr. Chairman, for Pastor Todd Alexander to be chairman.
All right, a second. And a second. Any other names?
I'd like to nominate Jeremy Maxwell to be secretary. Secretary.
Okay. Do you want to do those together? Oh, we can. Is there a second
I'll
to
second
that?
that.
All right.
I just want to ask, why does this committee have a secretary and every other committee has a vice chair?
This was a CTAS template, and it was from CTAS and the state, and so this is how they had it.
I just wondered about,
So he made the motion, he made the motion.
I did.
All right, so a motion has been made for those two positions and a second. Any discussion? All in favor signify by saying aye.
Aye.
Opposed, like sign. Mr. Chairman.
Thank you, Mr. Hyde. I've never served on a committee like this, and all I can say is I'll do my best, and have done it in the church setting many times, and it is a very serious matter to do. We need to follow the agenda here under 4C. There's mechanics for processing the received complaints. When you look at the ethics and conduct policy that the county commission approved in November of last year, it outlines some of the process. Some of it gives us as a committee opportunity to kind of set parameters. The first area, there's a form, it's Exhibit D in your package. That form lists a complaint, and then down at the bottom, there's a place for the county clerk to sign off whatever action was taken, as well as the county mayor.
Mr. Chairman, if I may, this was gotten from the county clerk, and that was merely the execution point for the resolution. So my office has created a template that has removed that, and it just has the body. So that is not a
Same
requirement.
thing, just without that, okay.
Yes, sir.
Very good, thank you. So this exhibit is in this package.
It's an actual copy of the resolution as it appears,
Gotcha.
signed, sealed, and delivered to the county clerk.
All right, so the other, just the top part is
The relevant part, yes, sir.
the part that we need. Okay, very good. Those complaints can be turned into the county law office or the chairman of the committee. Our task, according to the policy, is to hear the complaints. In hearing the complaint, we also hear the accused and then investigate. One of the areas, as I read it here, is we need to kind of set boundaries for hearing the complaints. The time limit is set by this committee. Anybody have any thoughts on, we want to give X number of minutes to hear the complaint, and X number of minutes to hear from the accused? Yes.
Mr. Chairman, I don't know if there's, I spoke with, Chairman Hyde alluded to earlier that there's not been, when he served as committee, there was no complaints over my previous 4 years in the commission. So one came forward to the commission last summer and actually spoke, I called one of the petitioners today over that. And unfortunately, at the time, they didn't allow the petitioner to present their case, which was odd. I mean, I found that bizarre, or the defendant didn't even show up to the hearing. So basically, I don't know if you need a time limit, if we're going to give one, I don't know, 15 minutes, or I definitely would like to, we can have a question, I'd like to have a question and answer time.
Right.
Of each, to ask questions specifically. That were basically on that list, that their characteristics
Yes.
question.
Yes.
Which I think was the reason for the complaint, one of the petitioners being her husband, being having that, but I don't know, 15 minutes?
Yeah, it says, give them adequate time, how much is that?
Or is there a time limit? I don't know.
Right. It just said that the time will be designated by the Ethics and Conduct Committee, so.
I think 15 sounds good, and then I guess in that situation, if it's a situation where there's a lot more to say, they can hear the request and
Where is
conduct
that?
it and get that.
Yeah.
I want to read it to myself, because I may have a different interpretation. Where's page?
Section 5.
Section 5,
Second page, section 5.
accusation and ethics and conduct relation accused may have adequate time to present his or her defense, and adequate time will be designated at the beginning of the hearing by the Ethics and Conduct Committee.
I said, Mr. Chairman, that I wasn't going to.
We yield to your experience, sir.
What I meant was the next meeting, and not this one. I feel like this is we're looking at it from a different angle than a person being accused. And legally and technically, I think they could say, how can I possibly explain this situation in 15 minutes? Chairman to use discretion in that, and I think it would be good if we sit in there somewhere that the this one, for instance, could be done in 15 minutes. We may have a very complex situation that could
But it says it will be designated at the beginning of the hearing, so it could change depending on, can you do it on a case-by-case basis too?
I think as long as we have in there that the chairman sort of use his judgment to guide the time process along.
I mean, I could see some of them going on and on and on and on.
I was at the one that Commissioner Mansfield alluded to, and it was a joke. It lasted, I think, about 10, 15 minutes. There were numerous complaints. They just swept them all over the road.
We certainly don't hope that's the due process. That anyone would say it was a joke. Our task is also to investigate. Certainly want to have time to ask questions. Because the complaint we have, there's a lot of questions. So we'll just kind of do that, and then if it comes try to bring that to a halt.
Do we need to make a motion for that? Just put that parameter, or do we need a motion, what you suggested, make a motion for that, for setting that, actually leaving it at the discretion of the chairman on how much time is adequate
I think it'd be
of the
better.
plaintiff and the accused. So,
And he can consult with the lawyer or whatever, and, because, you know, there could be things to follow the decision or hearing of the committee, and we need to, you know, have a lawyer's advice. But I think to make a motion that we leave it to the chairman, would be good.
I'll motion that we leave it to the discretion of the chair as to what adequate time will be designated during the meeting as the meeting proceeds, so that there's plenty of ample time for questions and answers. I need a second on that, folks.
Okay. We have a motion and a second to leave the time that the complainant and the accused has at the discretion of the chair.
Both, right? Both the complainant and the accused.
Both, yes. Yep. Sorry, I've got dental work I've just done. I'm not very plain just yet. Any discussion on those? Those in favor, say aye. Aye. Opposed, say nay. It is carried unanimously. One of the options that we have as a committee is to ask the law director for his opinion and/or recommendations. Mr. Sibley, is there anything that you want to advise us on as we go into this process?
If I may, this is really dangerous ground, and I think the committee needs to be kind of held to a higher standard than some of the other committees. And the reason I go into that is the second this complaint hit, I was getting bombarded with requests for who the complainant was and who the accused person was. And this really gets to do an ethical quagmire for me, because my client is the commission as a whole. So when we rise to the level of this kind of complaint and this kind of committee, I think it needs to be a standard policy that all questions are forwarded directly to this committee, because I do not know what information the committee wants to use. I do not know what they want to further investigate, and I don't want to be giving out stuff through requests from other commissioners and whatnot. And I think there needs to be some standard rule by this committee that any request for information will be dealt with directly from the committee. And that would keep not just my office, but any other parties that may get drug into this, they've got some sort of this isn't my rodeo here, I'm watching, I do not want to be a participant. So, I just wanted to make sure I expressed that this evening. Other than that, I'm at y'all's service, so whatever you need from me beyond that, whether it be legal research, opinions, AG opinions, whatever I can find on whatever we're dealing with, I'll be more than glad to report back. And I don't think I'm going to have much input. I should have much input on what the outcome is. That's entirely y'all's decision. But thank you for letting me get on my soapbox.
Yeah, well, you look like you were ready, so. Can you help, I don't mean to put you on the spot, by any means, but can you help us with the confidentiality aspect of this? Is anything confidential? Is everything confidential?
The only thing that would be confidential is if we went to special session and you all had some direct legal questions of myself or my cohort here, and we could move it to special session, or you could kind of do a hybrid meeting where it's a public meeting, you know there's going to be an executive session or that you need to talk to the attorney, and then you end the public part, and then the rest of the meeting is under executive session. But other than that, y'all are under the same rules as any other committee. I didn't find anything to the contrary, did you?
I'm not just the standard stuff, like there's like, social security numbers or,
Well, yes.
standard stuff like that. And we could double check that with you guys as well, just confirm that, just to make sure we're,
The biggest thing it hit, and, there were emails and phone calls, hey, what is this, who is this? And I wasn't sure, we hadn't even met yet. I wasn't sure.
the Open Records Council has a list of all the exceptions to the Open Records Council has an extensive list of exceptions to that, several pages long, so I can go through and review it to make sure we're accurate on that. But I think what Mr. Sittler said is accurate, to the best of my knowledge.
Do we need to make a motion for what he suggested, so that this specifically spells out the fact that if anyone has questions, he is not going to answer them, they would need to come directly to us?
Direct to the committee.
I'll make that motion.
Would you like to make it to where it's direct specifically to the chairman?
Yeah,
Yeah, I would.
that makes sense as well, yeah. So I'll make the motion that any questions or concerns for upcoming case that we're going to be addressing would go directly to the chairman.
All right, we have a motion and a second that any outside questions from this committee would be directed to the chairman. Any discussion on that, thoughts? All right, those in favor, say aye.
Aye.
Opposed, say nay. Passes.
Mr. Chairman, I'm glad I'm not going to say anything
After this meeting.
I could see down the road there, someone being guilty of sin, and a committee that did not really want to perform their task, and letting it ride on indefinitely. Maybe for a particular vote, or just not act on it. I think you need to set a parameter of 48 or 72 hours. The final decision would be made following
On the hearing.
Or some other time frame, but I think we need to fence that in.
Okay, Mr. Chairman, so you're basically saying, you're talking about once we actually, because today we're going to be setting the dates to execute this. You're saying basically, once we hear this, I mean, obviously we can deliberate, make a decision then, or you're just saying?
You could, but I think from the time that you have finished the business of the committee,
To set it.
well, within 72 hours, a decision, it could be right at the meeting, or it could be, but put a time on it where you could not just keep dragging out.
Kicking the can down the road.
Right.
I would hate to put like 48 or 72 hours, because that means we got, one, we'd have to do a special call meeting notice, we wouldn't even meet the statutory requirements for that one, but it'd have to be probably like a week later or like.
Yeah, I'm not having it at any time.
Well, I was gonna say, like, I would think, maybe we make a motion to, as part of our procedures, to set a timeline once the hearing is done, but not put a limit on when that timeline is, because we might go to a week later, it might be next month, I don't know, so I'll make a motion, I guess, to.
If I may, before y'all do that, you might want a cleaner way to do this might be a timeline based on receipt of the complaint, that there will be a final determination within 6 months, within 3 months,
60 days, 90 days.
and then that gives you plenty of committee movement room and voting, and if some action does need to be taken that involves a commission, it can be dealt with there as well, but it gives you a nice, clean starting point and stopping point. But that's my suggestion.
So X number of days from when the
Date of
complaint is filed.
So it was received this last week, in April. Whatever Friday was when we received the complaint, we received it on Friday.
If you got it when I got it,
Okay, so, I mean, that.
or the committee, I should say.
3 months, I mean, that puts you in July.
60 days on it.
I mean, 60 days, which means, we had to, by the end of June, have made a determination and had the hearing. So, you were saying 90 days?
90,
Mr. Chairman, if I may, I hate to interrupt, but I do think there's kind of two, but I do think there's 2 dates, like you just alluded to that. There's a date that you actually hear the cause, and then there's a date when you make a decision.
If needed.
If needed,
You don't want to
right.
be too close together.
Right, yeah, but I do think in due process, you should have that as quick as possible, and then set your final date based on that information. Y'all may have to do additional research. There may be questions raised after that. It's kind of hard to say if it's going to be 60 days. I think 60 days should be adequate to accomplish just about anything.
You could vote around it, couldn't you? You may do the extenuating
But you can always, yeah, you can always extend it.
Right.
This is just for this hearing, so we should know what's in our own rules, but, I would say, basically 90 days, the date, upon the complaint is to have the determination made within 90 days. That gives you, because unfortunately, we were going to meet a week after the complaint, less than a week after the complaint, it could have been like 3 more weeks from that schedule, so I'm just trying to get into the timelines. That's my motion, is 90 days.
We have a motion and a second to establish a policy that the case would be heard and a decision made within 90 days from the date it is filed.
Date is filed, or
That's when you receive it, right? Whatever date we receive it.
This is a general policy, just for this case. Just for this case. Yeah, because we're not revising the resolution, and this is, so I think it's good full commission.
So, Harry, if a decision was not made in 90 days legally, it's null and void.
You might need to make that a part of the minutes here, is that if a determination hasn't been made, what does happen? And in the legal world, usually that's some sort of acquiescence to the fact that if you had nothing to go further with it, therefore that person, the accused, is deemed to not have done what was alleged, or reached a level of discipline.
Do we need to put something in there? That if circumstances prevail, it can be extended, or is that just a simple,
But I think you can do that anyway, but yes, if you want to get it in the minutes as well.
just a,
I'll motion that should we need an extension past 90 days, as part of our procedures, that we can exercise. We need more time.
you're going to amend your,
Well, we've already made, it is an emotion, we already voted on it, so.
motion and a second to include that if, due to circumstances a decision has not been made in 90 days, we have the option to extend for additional time. Discussion on that?
Yeah, well, I agree with that. However, we're getting down to what Commissioner Hyde was warning us about, kicking the can down.
We certainly don't want to do
We
that.
need to have a final, and that's it. You know, and I agree, there may be extenuating circumstances that come up that we need to look at, but we need to have a hard cutoff date.
If this is
Well, what
a
is that?
very serious offense, you have this person sitting and making decisions, maybe on matters that involve what they were even accused of, so I think it does need to fence it in somewhere along the line.
I mean, I like the 90 days, and I feel like the extension is good, but what if we just cap the extension at an additional 30 days?
30 days.
And then that's like, it's not just open-ended, it's just an extension of another 30-day extension with approval.
So you make a motion, and amend that?
To amend,
Yeah, I'm making a motion to amend that.
I'll second it.
extend 130-day.
Sure.
Feel like that would help?
Do they know about that?
Been my experience that you usually don't get everything the first go around on certain situations that you have to deal with, even though they say, you know, that's it. It's rarely it. So sometimes it just takes, as you peel back the onion, it takes more. So if you have a motion to amend the motion to add 130-day period extension. Any discussion on that? Those in favor say aye. Aye. Opposed say no. All right. So that passes as well. Before we move into item D, is there any other ground we need to cover as a committee?
What is the actual process for someone, they fill this out and it gets sent to their office and then they were sending it to you? Okay.
And they could actually send it directly to you as well.
The policy says either way.
Okay.
Yes, committee chairman of the laws.
Eric, do you think that we would need to speak to the right to present information to the committee and witnesses? Like, okay, I was in a conversation with someone when this happened. This person saw what happened, and I'd like to have them, see what I'm saying, there could be situations like that, but you think we need to speak to that as to whether we would allow that?
Well, you're not gonna have any kind of powers to persuade somebody to come and do that, but if
This would be-
people voluntarily showed up, it's entirely up to, this is what I love about the law, is the vagueness of it, is that's your investigation, shall investigate, y'all get to pick what that means. So if you want to allow people to put on witnesses, I would take the old hearsay standard, I wouldn't let them talk to what they heard so-and-so say they saw happen, but if you've got direct witnesses, that seems reasonable to me, especially if it's on the defense side.
Or
No, either.
video evidence.
I mean, this is how it's presented.
You say that, but I was sitting here thinking about the fact that it is important that for 2 years, not 90 days or 30 days beyond, but for 2 years, something hung over my head. And it was not until it went to court, and it was drug out, that was not reason that there needs to be a fencing in of facts. And of course, when it went to court, the judge from another county that observed the video that had been cleaned up by a friend of mine said, and this was see what happened here, this is not true, and I'm throwing this out. But things like this could drag on and on and on, and there are situations where you would like to have someone come and be able to speak or say something. But I think time limits are important. Witnesses could be important. But it needs to be documented, because here's the situation. I look at the people sitting at this table, and in my heart, they're very honorable people who would do the right thing regardless. But it may not be the case someday out there, 20 years from now. And even one of these people could be sitting before a committee, and if a lot is left up to whatever the committee decides, they could decide something that would make the person. I think some things need to be spelled out.
You bring up another point, if I may, Mr. Chairman. We're going to have to put the accused on notice of these same requirements that we're discussing. They can't just, we can't know what the time. So I would strongly encourage whatever comes out of this, that the accused is also appraised of what timelines are so that they can maximize their time as well.
Yeah, that's what I think part of the resolution says is that basically the accused would have adequate time to present his or her defense. So that is, that they have to have adequate time, so that is actually baked into the resolution itself.
And the one right about that says have a representative of choice present during the public hearing. So they would have somebody with them if they wanted to. As the representative. It doesn't really go into the details of, presenting their case. It almost kind of sounds like it's our opportunity to question them. It doesn't really outline it as a thought for them to stand up and present, but we're saying we want to do that. Is that something we?
It says, adequate time to give and present their defense.
Yeah.
And that defense may include first-hand witnesses,
Video.
video evidence, whatever.
I won't make it audio picture, because it could be audio.
Sure. Once we have a recommendation, does that go to the county commission?
Legislative, correct?
Legislative committee? What was the next
Well,
step?
it says on 5 and 6, in that next page, if it's the county commissioner, if it's appointed member of any county board or committee, in the case of an employee, but I didn't, so will we be possibly hearing cases of county employees? Yeah, because like in a county employee, it says refer the matter to the official responsible for supervision of that employee for possible disciplinary action if the official finds discipline warranted. So there's different scenarios.
This is the page we're really going by.
Okay.
This previous page where we can refer the matter to the office of law director for legal opinion and a recommendation for action. We can refer to the county legislative body for reprimand or public censure.
Yeah.
If the legislative body finds such action warranted, council and the county commission chairman, removal of board and committee assignments until such members are restored to good standing or permanently replaced. And the proper rule of order actually, when a member is out of order, or has been censured by a discipline, the Robert's Rules of Order does cover discipline in the sense that, like, it might be a public apology until such a time, an unruly commissioner can be removed from the legislative body for the rest of the meeting, or until they apologize and come back and be restored in good standing. So Robert's Rules does cover that as well as this. I mean, or, removal from their sign sheet in the commission chambers if they're hostile. So it's not outlined there as far as conduct.
Right. And
I have them, officially, basically, removed from any boards, or committees to be, the committee, I guess the ethics committee can choose that, as to remove them from boards or committees, is what it says. So,
For county commissioners, because there's
Correct.
1, 2, and that's county commissioners, and then there's 3 and 4 on the next page is if it's not a county commissioner, and that's what my question was.
1, 2, 3, 4 are all on that.
The number's a little bit off.
Yeah, some of those should be indented.
Right, so 1, 2, 3, and 4, 5, and 6 are indented under 2.
Correct.
Seven county official, and then you go down to 3, and you're talking about whole new people, not county commissioners.
Correct.
So that was my question, was a different process happens with those people, because they would be referred to not legislative, not the chairman of the commission, but other people. So I was wondering about those, or questioning.
This is not the case here, so it's not applicable.
In this one.
Right.
I mean, this is not applicable.
I don't think it would be wise to put a lot of committees between your action and the full commission.
I really don't think you can, to be
The
honest.
full commission and, or a department head or whatever, but we don't need, you are supreme as far as the decision on ethical conduct, and it shouldn't be drug out through committees, it's straight to the commission.
Well, if warranted, I mean, it's not even necessary according to the way it doesn't have to go to full commission. That's not necessarily an option, it doesn't have to be an option.
I think you want everything, you want everything to go to the full commission to have the force.
I mean, you can, or be a majority vote according to Robert's Rules for any kind of disciplinary
Yeah,
action.
I think it'd be wise on our part for it to be a full county vote.
So we should make a motion that any decision of this committee under the resolution should be sent to the floor of the full commission for final. I'll make that motion.
Are we talking about just for negative impact, or what if they're deemed not to have been risen to the level of,
Whatever the decision.
so even if it's to that it go away? Okay.
So our recommendation would be no action or
Oh, okay.
whatever we,
Make a decision, and that's the end of it. When they said no action on that horrible case, they got one this summer, they said no action, and that's the last, no one else heard of that.
So this committee just makes a recommendation and we don't make decisions.
everything I've read in here said recommendations, so.
Okay.
Yeah. But I just wanted to make sure that I understood it.
Yeah. I, for some reason, understood that only if we felt action needed to be taken, then we would be referring it off. But if we felt no action needed to be taken, that would be the final decision. But is that not how you interpret this?
Yes, I interpret it that way, but the question is, does the commission still have to ratify it?
Or do we present it to them just so they know we handled it, we found?
I mean, you could simply do it as a new business item and then do away with it.
This resolution here says the committee may, and that lists the remedies, except for the number, number 1, for the mayor of the county, what it said about the reprimand. That's the only time that it would go there, is the ordinary language of this resolution.
That's what mine.
That was my understanding as well.
Yeah, anything else to be decided by this committee.
Okay.
That's why I was interpreting that. That's why I was, but the recommendation from Chairman Hyde is that regardless of what the decision is, based on any of these, is that all goes to the county.
And I thought that's the path we were following, just
As a report or for their stamp of approval?
For them to have final approval.
do we really want that on our shoulders by people? I think the commission will listen to what you have to say after you have looked at the facts and so forth. But you always have to look beyond this committee. It's to go to the full, I think, the full, for ratification, the full county commission with the recommendation.
So, the motion, I'm trying to read from the notices, that I motion that Commissioner Brown seconded, that any decision made by this committee would go to the floor of the full commission for a final resolution by majority vote.
So, can I ask a question, sir? So like we were saying, really on number one, the only one that talks about if there's certain action, it should go to the legislative body to choose and decide that action. But for instance, let's look at number two, counseling with the county commission chairman. So if our committee decides they really just need counseling with the county commission chairman, they just need him to have a good talking to. We need a whole legislative body to agree that that's okay, that we should do that.
Based on this motion,
I think, Gina, that would be wise to do because it could be a more serious decision than that. I mean, then you get into a level of what will and what will not rise to that level. And I would stay away, I think I would stay away from the word, send it to the commission for a resolution, because I just say ratification. I don't think they should change necessarily what you all decide, but it should be ratified. If you say resolution, I can see full debate going on at the county commission. In other words, where it's this or not at all.
We don't want to rehear the whole thing.
so, I guess we could say, I mean, you're saying, any decision made by this committee would go to the floor of the full commission for final ratification of the decision.
That's just a yes or no
Yes,
vote.
for a yes or no vote, yeah.
With no debate.
No, I don't think any debate, but the debate ought to be done here, the ratification there. We can be there for
You'll be there.
I know,
But it provides some closure.
Yes.
All the commissioners know, we listened to the complaint, we listened to the accused, this was our decision, following investigation and deliberation, and it's a matter of record that whatever was done, counseling with the commissioner, suspended from committees, whatever, that they would know that it's done. I think would help with some closure on some of that. We have a motion and a second. Is there any further discussion? Those in favor say aye. Aye. Opposed say no. It passes unanimously. Love the process of working it out. Is there anything else we need to discuss prior to setting a hearing date? Move on then to item 4D. We have received a complaint again, having never served in this way. Mr. Hyde, do we set the date? Do I need to consult the two parties to set the date?
I think that would be wise, because they could even be planning to be out of town when a date is set, so I think you ought to consult with them.
And then go back through the
But there needs to be a safeguard in that if they just keep putting off.
Right.
And that the chairman can set a date if it seems like a date is not,
right.
Because they can't have a representative. We've already said they can have a representative, then they'd have to resort to that.
Right.
So, my question, like, for us, we can discuss now, so, I would prefer not next week, because we have a lot of committee meetings and budget workshops, so,
First 2 weeks of the month not good, is it?
Correct. So I don't know, I don't know if Wednesday the 10th is too early, or if you guys don't want to do it on Wednesday, I know you have church and you have church, so I don't know if we could do it like on a Thursday, a different day, or because we probably need to do it around, sooner than 5:30 or so, to allow time for people to get on here after work, that actually, so 5:30 to 6, I don't know if we're setting a time, but trying to find it. I don't know what Thursday the 11th looks like, or what Thursday the 18th looks like. I probably wouldn't want to push it out any further than that. That's looking 3 or 4 weeks away.
From this committee, what does May 11th look like?
I can do that.
I can do that. She doesn't typically say 5:30, or is that too early?
Is there a board of zoning?
There it is, at 5 p.m. It's not in this room.
Yeah, okay.
I'm not sure, there's a possibility that I might be in town.
On the 11th. And you guys can't do Wednesday night, correct, Bob?
That's Thursday night.
The 11th is, it's, I can do the 11th.
I can do it.
We're not set today, we're just tentatively saying that, and you're gonna reach out to dragging this out, like, I can't make it that week either, we're gonna do it anyway, we do there.
Right, exactly.
Right. Once you get beyond reason, we're gonna set a date.
What time do you think, 5:30, 6, what do you think, like?
6 is good.
Like, whatever, 6 p.m.? Okay, problem, Mr. Mayor, for getting in?
I will make sure the room's available. Assume that it is unless I say anything different.
6 p.m. start time.
6 p.m., yeah.
It's not very prompted.
Mr. Sittler, when we contact them, I assume giving them both a copy of the complaint is...
It's public record now, so they can make an FOI and get it, so I say yes.
So the question, somebody asked us for this, we can just go ahead and email it to them, and like, I wasn't gonna do it beforehand. Because
Until we met.
we had enough of those lawsuits against the county commissioner things, and I wasn't gonna be partaking.
I would say yes for 2 reasons. One, selfish, but y'all are the committee, and secondly, y'all are the ones I told them they need to reach out
They need to
to.
go to the chairman, don't they, if they want?
Yeah, that's right. Yeah.
They need to go to the chairman, they need to, so you just say, somebody asked you for it, so you're gonna have to contact the chairman.
Okay.
Correct?
Yeah. This will be obviously included in the minutes of the next meeting.
Sure.
And we'll have it.
So I will send them a copy of this, which one party already has it. And then,
There's another side to that, too. I don't know if you noticed
Yeah.
that. Okay.
that's a fine two-sided.
Okay, so you just let us know. If they can't do mail, so you're gonna reach out to them about mail.
Correct, and then I'll contact you guys, let you know either way.
Yeah, confirm the date.
Either way. I think,
We want to set a backup date and time in case that doesn't work, or if everybody's going to schedule real quick. That week, 11th, doesn't work. We have a full commission meeting on the 15th. I don't know if you guys would want to do it on Tuesday the 16th or Thursday the 18th as a backup.
I'd rather Tuesday, you know where I'm gonna be, board meeting.
Okay, so Thursday the 18th as our backup?
Yeah.
Dates,
we can do that.
just same time, same place?
What's the name?
Brown?
Yeah, I'll make one of them. I'll be here.
Supposed to be closing time.
would, highly recommend, that we have meeting this hearing in the chambers with the chairman at the, main desk, and you all seated at a table somewhere with, him able to come forward and speak at the microphone. Settings are very, very important. The atmosphere and so forth. That's why in a courtroom you have a judge elevated, the decorum and so forth. And I think it would be to our advantage to have it in the chamber.
So,
Is that available?
I can double check, I'm sure it is. It's on the resolution. Yeah.
now,
Wait a minute,
you guys,
zoning
I
dispute.
mean, does somebody know how to operate the microphone system? I don't. I mean, the one you can't hear in there, it's such
The
terrible.
mayor knows everything.
Mayor knows everything.
We can, yeah, the microphone.
Board zoning appeals is that night.
Yeah, we wouldn't be able to do it Thursday, the 11th, we could not do it in the chambers, we got to do it because of the Board of Zoning Appeals spots, right?
Well, we can do it here, that's just a suggestion, I think the atmosphere and the setting would be much better if we can do it, so that it doesn't appear to be just another meeting. I mean, we shouldn't meet unless it's rare and important.
Do we want to go ahead and just go into next week
The
then?
18th, I mean, do we,
So you guys aren't available earlier that week, okay?
I think y'all are going to know something until you hear from them, you're really not gonna know.
I can meet with, Wednesday night's open to me, it's not open,
Yeah.
so, but I can meet next month, I prefer not to. Too soon, between time. So, the 11th would be here, 12th and 12th, and 18th. That didn't work, we can meet in the chambers.
So I'll present the 18th with the 11th as a backup.
Okay.
Yeah, we're going to do it, yeah.